brought it up.
You just broke down law school for her. How am I different?
I didn't break down law school.
Okay, I'll tell you.
He asked the
We
question.
have told you.
All right, I'm done. I'm going to set it for that.
Oh, right. Well, I'll just stop. We've been here previously. I thought we were coming for preliminary examination and relayed that to my client. He has discovery, but in the meantime, he got a second case on the same complainant. That has caused this to be converted, in my opinion, to be
A second case on
the same, calling from the jail. Allegedly, everything's allegedly.
the
Calling
witness.
from the jail.
Right. Okay. He picked up the,
Everything's alleged.
right.
So that caused a second case, and in my opinion, a second PCC. So we want a preliminary examination for everything. The people have advised me that they will go forward with or without the witness. I explained all this to my client. He exploded. So
What?
exploded. Well, so I didn't know what I was doing.
Okay.
So, and not fighting for him. And that bothers me more. They can tell me I don't know what I'm doing. That annoys me. But when they say I'm not fighting for them, that goes to my core, since I come from a fighting family and I fight for everybody.
Oh, you do.
No, that just is making me talk to you. I am going to fight, but I got to fight within the rules. And I feel I know them a little bit better.
Counselor, I'm just trying to figure out, he told you weren't fighting for him?
Oh, for sure. And a lot more too.
Okay.
Yes, that's why I want to just express myself.
No, yeah, that's fine. You know, it's kind of funny to me when defendants sit up there, they're in custody, they find themselves in more trouble because you were trying to set this. You were fighting for him. You were fighting at me a little bit with this thing. And then has the nerve to say to you, you're not fighting for him, when the reality is, at least allegedly, he's doing the stupid thing that's making your job harder. So that's fine. That's the way he wants to look at it. And the other thing is, and it just amazes me with some defendants, they come up here, they complain about their attorney, and they don't even realize the jewel that they may have representing them, and also don't realize, that fight is it wasn't quite anything you did. It's just in your blood.
Thank you.
It is your heritage.
I was carrying.
He doesn't understand that. He doesn't understand that you got to play by certain rules. He just wants to do it his way. So if he wants to do it his way, we'll do it his way. It's not going to turn out real well. So what do you wish for me to do, Ms. Ford?
I'm asking that we set this for a preliminary examination, that you hear from the prosecutor and my client understand that I am really putting forth a top effort. And along with fighting, I actually have skill. So I hope that he understands that.
Well, he also needs to understand that there's going to be a motion for them to proceed by forfeiture, I'm presuming. And that's going to make your case whatever it is. And I know your counsel will be ready to go forward. I know the prosecutor will be ready to go forward. But you understand that, Mr. F?
I understand everything.
Okay. Then let's
Right.
correct.
So
Just to the court.
he has discovery on the first one.
On the first case, but not on the second case.
Right.
How many, there were phone calls, so how see all of that, go through it all. So I want to make sure he has time so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You can have to explain that.
Oh, excuse me. Let me put this on the record. I did explain that I guess it's hard to understand the various exceptions to hearsay and how in certain instances they can go forward without the victim. I was trying to explain. And then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 327 Mishap 319. Would the court please explain to my clients certain instances where they can go forward without the victim? Excited under its mental state.
There are exceptions to the hearsay rule. Given that this is a domestic violence case, there's a statute which would apply which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of the simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Epps, and so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
One of the technicalities would be MCL 768.27C. And as I indicated, that case, People versus Only 327, Mishap 319, and the various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
yeah, I mean, it's all
And
all
other.
of that kind of thing.
Do I
They
got a
will-
right to cross-examine my accusers?
You know what? Here's the thing, sir. That if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could. I'm not, I know, but I'm just saying that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
I didn't break down law school.
Okay, I'll tell you.
He asked the
We
question.
have told you.
All right, I'm done. I'm going to set it for exam.
I'm going to go to the jail today, so I will. I'll tell you.
Preliminary examination in this matter, because the
Yes.
people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Just. Yeah, don't turn your back on it, please.
September 17th, 2024,
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 p.m. Oh, wait a minute, excuse me.
Why so long? That's 3 weeks.
Yeah, September 17th, I can do that, but not the
wow.
8th, because that's the judge's calendar. And I'm a deferred professor. There are some
You can ask
parameters,
for
and
another
you are not
speedy day.
being. Oh, that's the new
In-
thing in the jail I'm learning, that I'm being.
And I would anticipate the
Oh.
people's motion, so we'll try to
Speedy
hear
trial
that.
is the new
before the-
buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the.
That has,
Can I ask a question? What is about what's going on in the jail? Speedy. None of this
You
particular
just
about
said
my
speedy.
case.
You just said you had a right to
Like
speedy
this,
trial.
I didn't say. I asked why so long. I didn't say nothing
It's
about
not a
no speedy
violation
trial.
of speedy
I
trial.
asked why so long. Like Judge Sim, this is where we having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case.
okay,
All this
but Mr. Epps,
speedy
hold on,
trial.
slow down. You have two things now, which have,
And I
hold on. You asked me a question, but you're operating off of a premise that isn't going to work. So here's the thing. You had the one case come up. We then had the hearing. There were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure. The allegations have been made. There's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay.
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you.
And I'm not trying to do that. I'm just trying to explain the process, and I've got to, Mr. Epps, I've got to be fair to both sides. So I got to have it work out. You would have had an exam before now, had this not come.
That's understood.
Okay, so that's the reason for the stretch out in time.
Okay.
Also, the other thing, so that you just understand, it's not anybody trying to delay anything. Because of the allegations that come at, and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed, presumably, and I don't know if they know this for sure, without witness. Your counsel has to try to do some things. I've got to give her time to do that for your protection.
Okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
Can I say one more thing, sir? Yeah, my court hearing that I will be able to get a hold to her when y'all took my phone.
Excuse me?
At my last court hearing, y'all took my phone.
A courtroom hearing that was supposed to be a routine scheduling discussion quickly turns tense after a defendant accuses his own attorney of not fighting hard enough for him. The defense lawyer becomes emotional, explaining that she has been working aggressively on his behalf. But his alleged jail phone calls created a second criminal case and complicated everything. The judge strongly defends the attorney, telling the defendant that many people fail to realize when they actually have a skilled lawyer fighting for them, and that his own actions are making the case worse. The hearing then shifts into a discussion about Michigan's forfeiture by wrongdoing rule. The judge explains that prosecutors may still move forward without the victim if they can show the defendant's conduct caused the witness not to appear. That could allow hearsay statements, police testimony, and prior statements to be used in court. The defendant becomes frustrated, arguing that the judge is explaining legal concepts to the attorney but not directly to him. The judge responds that criminal law is technical, and that is exactly why defendants have lawyers. As tensions cool, the court schedules a preliminary examination for September 17th. The judge carefully explains that the delay is not punishment or a violation of speedy trial rights, but necessary because the new allegations and additional evidence need to be reviewed properly. Before the hearing ends, the defendant complains he cannot contact his attorney from jail. The judge immediately orders the issue to be looked into, ending the hearing with a reminder that communication and patience are critical in complicated criminal